lot of the business world watching the Supreme Court in these two cases today that could have a major impact on social media companies and certainly have a major impact on First Amendment rights as well. So the tech industry alleges that laws that were passed in Florida and in Texas in 2021 are in violation of the First Amendment. After hours and hours of oral arguments, the Supreme Court seemed at least skeptical of these laws and that would essentially prohibit the social media companies from making editorial decisions. So let's explain this, put it in some context here, both for the companies and the legal side, which will be covered by Misty Marris, who you see there. We also have a senior policy reporter at The Verge with us, and Lauren Feiner to break it all down. So Lauren, I want to put your piece up ahead of this, and then you can talk about the context of what we heard today as well. The headline being the Supreme Court's about to decide the future of online speech. And this does speak to how important this case is. It's very, very important, could have an impact, as you write about, on other publishing industries and future social media regulations. The cases, one is Moody v. NetChoice, the other NetChoice v. Paxton, deal with the constitutionality of laws created in Florida and Texas, respectively, though there are some differences between the two laws. Both essentially limit the ability of these large online platforms to curate or to ban content on their sites. So this, could change everything in a lot of ways. I mean, it's a big. I know First Amendment watchers are really watching it, but for these companies, this could be a huge change in their business model, right, Lauren?
Yeah, absolutely. People that are watching these cases are saying, if the laws are allowed to stay in place, it could mean that tech companies have to make really hard decisions about how they deal with content in ways that they haven't in the past. They might have to either take down a lot more categories of content to avoid being held liable for speech that's on their platforms, or they might have to leave up a lot more content, which some say would make the platforms a lot less attractive to users because it might host a lot of speech that people aren't as comfortable with. Now,
all this showed President Trump video of the former president January 6th. A lot of this, after he was banned from Twitter and all the rest after the 6th of January 2021, this all came into light. Let me show Chief Justice John Roberts from the arguments today, Misty, and let's see what we can make of this. Social media platforms, the internet, all that stuff, it's an incredibly dynamic market, the Chief Justice said. The government, maybe not so much. So what would you read into that and what we heard from some of the other justices today on this case?
Now, having watched the oral arguments and seeing some skepticism from the justices, and this is not just how we usually see the Supreme Court divide party lines, this was justices from both sides of the aisle. So there's a skepticism about what this would mean and the implications of the First Amendment. The first is all of these platforms are private businesses. The First Amendment actually does not apply to them. The First Amendment applies to the government. It says the government can't compel or stop someone from protected speech. So that would be an extension to these private industries. And interestingly enough, the arguments that these platforms are stifling speech relating to conservatives, that's the basis of these two state laws. Actually, the justices are saying it could actually go the other way, because now it would be compelling private industry to post every single opinion. So they're very, very specific legal arguments relating to that First Amendment quandary.
Yeah, because a conservative point of view on all of this would probably be counter to what maybe, I think it would be, maybe you correct me if I'm wrong, what maybe the conservative position politically is in this case. We see that a lot, the way politics has kind of shaped up here the last few years. I said earlier, Lauren, that a lot of this goes back to January 6th when Trump was banned, but put up his tweet from before all of that, because this gets to kind of misinformation on these social media platforms. This was back when Twitter was Twitter, when they used to call it that. Statistically impossible, the president at the time tweeted, to have lost the 2020 election. Big protest January 6th in D.C. Be there, he told everybody. Remember, he said this, it will be wild. This was before. But obviously, his comment there, statistically impossible to have lost the 2020 election, is verifiably false. It's a lie. We knew he lost, and we knew at the time that he had lost the election. So if a company wants to take that down or even ban the user who made that comment, the argument should be their prerogative. So to Misty's point, it seems like that's the way the justices might be leaning. But what's your take on it?
Yeah, I think the justices are really grappling with what are the free speech rights of the platforms themselves. Like Misty was saying, the First Amendment is about the government and the government's ability to censor speech. But we're talking about private companies, private platforms that make decisions about how they display information. And now the question is really, are they more like a newspaper that makes editorial decisions, or are they more like a public forum that the government can say, you actually have to host some speech because you're putting yourself as open to the public?
Right. That question of whether they could make editorial decisions or they're just a platform, that's come up in a lot of other contexts in Congress and everywhere else, and probably will for years and years. Let's leave it there for today. We'll come back to this. This is a very interesting topic. Misty and Lauren, we thank you both.